How's everybody doing? Anybody need to stand and stretch? You won't hurt our feelings. It's okay. Well, I have the opportunity to introduce our next speaker. Kelly Cross is an elder law attorney here in San Antonio. My first interaction with her was really when she did some work with the Alzheimer's Association on their Speakers Bureau, but then I got to know her at an after-hours function, and that was a lot of fun. She actually bought a silent auction item. My husband is a fireman, and he donated an afternoon out at the fire station, and she has a couple people that she hangs out with. And do you call them are you guardian for the girls? Or? I'm a guardian. Guardian, okay. Okay, your posse, as Byron says. So we got to hang out at the fire station with some of her friends, and the best part is that the Sparky, the fire dog, came out and her girls went crazy. That was a lot of fun. The poor gentleman in that costume really got hurt in a not so great way. But anyways, let me tell you a little bit more about Kelly. Kelly is a native Texan, spending most of her professional years in San Antonio. Originally educated as an accountant. I did not know that. Spent several years practicing and teaching. Graduated in, has her MBA at the Law School of St. Mary's University, and graduated in 1992. Entered into general practice here in San Antonio. And now, this is where she wrote wills and probated estates and handled divorces and participated in mental health docket, even represented a few clients in some criminal law issues. So, as an attorney in San Antonio, Kelly enjoys practicing in the legal community with a strong commitment to service and a long history of helping those who are less fortunate. She became and remained active in providing pro bono services on many occasions when lawyers can help but cannot always afford to do so. And eventually and naturally, Kelly was drawn to the guardianship law practice, where she has distinguished herself in the field as a national certified master guardian. Let's welcome Kelly.
All right, can you hear me? I tend to project because my dad is partially deaf since a long time ago, so if it's too loud, you have to let me know. And the more excited I get, the louder I project. So, you know, today we went through a lot of information about legal documents. So what I want to do right now is just kind of take you through what we talked about this morning. So we talked earlier about a medical power of attorney. We heard language about a durable power of attorney. Well, that's the financial power of attorney, right? You remember those two this morning and the panel talking about them? Well, there was really not a lot of mention about directives to physicians and families about end-of-life decisions, what you would want for yourself if you were faced with heroic measures. What would you want? For me, save me, freeze-dry me until there's a cure. And so not everybody feels like that, but remember, elderly people may not be so excited about dying. I've had a lot of 90-some-odd-year-old people who wanted all heroic measures, right? So don't get the mindset that just because you're old, you're ready to go. I just went to a funeral of a friend of mine who was 97. He was a priest for 71 years, and he did not want to die. And I said, Padre, isn't this a win-win for you? Okay. We also heard about a trust. You heard Dr. Leatherman and some other people talk about a trust. A trust can be something that is right now during your lifetime, or it can come into existence when you die. So a trust, that's a pretty big document. We also talked a little smidge about a pre-need declaration of who you want to be your guardian and who you never, 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 never want to be your guardian over your person or estate. That document, we all love that document, but there's nowhere to file it. And it's a very, very complicated document because a lot of attorneys just put it out there without any consideration to the cognition of their client. And remember, for the attorneys that are in this room, kudos to you for coming to learn. How many attorneys are in here? Raise your hands. Very good. I can tell you in the real world, attorneys don't want to learn much more than what the current law is. They tend to stress us out with that every 2 years. So coming to something where you have medical information, it's brilliant of them to supplement their education like that. And for the medical side, the same is true. We do coexist with the numbers of the graying tsunami coming our way. It is more important that we all act together for the benefit of the greater good of all for our elderly. So we talked about that pre-need declaration, and then we talk about a will, right? What is a will? That's the vehicle that you use to pass wealth at your death, right? So those are your 5 documents. Is there anybody that's confused about the 5? Because we've been going over them kind of off and on all day. Good. Then let's move on to more fun things. I want to talk to you about the relationships dynamics that I have seen in probate and guardianship litigation for the last 22 years. They truly are my favorite. And the title of this speech was End of Life as You Know It. Why? Because that's what happens if you live long enough with a progressive disease. Life as you know it is no more, right? So there are some lessons that we're going to learn from our American icons. But for right now, let's look at just simple dynamics. Anybody in here have a blended family where you're a second spouse or something like that? Very common to have another spouse where you have a stepmother and stepkids, right? That's more and more. We see relationships, divorces all over the place. My earlier conversation, Barbie's a divorce attorney and she's divorced a lot of people. In America now, divorce is just every day. But then people remarry, right? And then they grow old together, right? Let's hope. But there are a lot of people that remarry 3 and 4 and 5 times. Now, when I was growing up, my grandmother was married 5 times in the Catholic Church. Wow. Okay. She was a good-looking redhead, and she outlived every one of them, except for the last one, who was quite a bit younger. So we never had too many step anything because my grandmother was just that kind of woman and redheaded, and boom, we got a new grandfather. So let's look at the relationships. Now, the outline that you have inside your little book today is not the correct outline, and the name of the speech for the CEUs is not correct either. So if you call me, I'll send you the correct outline. But it's really, you don't need to hang on an outline because this is going to be more of a fun afternoon for you. I know Patty is a wonderful speaker. I always glaze over when she gets to the numbers part of this. I go to every one of her speeches. Actually, I have her frequently asked questions as a little app icon on my cell phone. So I suggest look it up every single time. So let's look at these relationships. In guardianship and probate litigation, children versus the step-parent. Very, very common. A relative, or the children, versus the old best friend. I have it in my outline as BFF, the old BFF. So it's the kids or the relatives who are always distant. Mom, dad, grandma, whoever the old person is, has got this best friend for the last 60 years, right? That's that relationship. Then we have the relative or their children versus the new best friend forever. That is a red flag for perpetration of something bad going on. So this is taught in many, many exploitation seminars. If you have a brand new best friend, all your flags, all the hair on the back of your neck should be standing up. So the last one, and the one that is not in your outline, but I've been running into this so much more over the last 5 or 6 years, is sibling versus sibling. And so here's how it comes up. It's kind of it's brought into the courtroom as, oh, well, mom loved me best. No, really what we're finding now is that we have the bully and the bullied. And the parents played a part in that. You had the parent that either let the bullying go on or insisted everybody stay separate. So we have that dynamics that did not change when the two siblings grew up, right? So we are starting to see more and more. And by the way, I think the most vicious litigation is sibling versus sibling. The worst among that is sister versus sister. Trust me. Nobody can love you more than your sister, and nobody knows your buttons to push more than your sister, right? So those are the big, big dynamics. Now let's blend that a little bit in with Texas law. Texas law favors the person named on the document. And then we heard earlier about, well, when are those documents signed? Well, if you're 18, you own a car and a house, and you're 21, 25, you should start getting those documents right now. Get them early. So what do we see? We see a lot of people right now, they did not get documents, or the disease is destroying the documents. How many of you have experienced a really good family member and the victim of the progressive brain disease or old age illness turns against that child and says, "You stole my Social Security money," right? So a lot of times, even if you have the documents, the disease rips them up, right? So, you know, there's a lot of ways that those documents are brilliant and they're there to be used and you want to have them early, but there's a lot of times that the disease ends the document. Or in our county, we see a lot of people that never went to get those documents. Why? Because the only thing an attorney has to sell is their time. And for my practice, you can call 15 attorneys for the same thing that you call me for, and you're going to get 15 different price quotes. So attorneys who don't specialize in elder law, attorneys that are, you know, divorce or criminal, they're going to charge more because that's not their common everyday document. So what we see is a lot of our real working families that have now aged out and they're very retired for the last 20, 30 years, they don't have these documents. And then there's, as the attorney, here's the funnest call I get. The doctor from XYZ hospital told me that I should call and get my mom a power of attorney. I said, okay, what's going on with your mom? Well, she's in a coma. So then you're, okay. So you give them the medical opinion form to go start the guardianship, and the doctor says, well, we have to refer this to the psychiatrist to confirm the coma, right? So it's fun no matter what you do. You have to have a little bit of stamina to get through the systems that are out there. Don't let anybody ever stop you from doing the right thing, and you'll know what that is because we all have a conscience, right? So now let's talk about something that you also heard all morning and afternoon long about guardianships. What about those guardianships? Well, it should be the last resort, so we're looking for any way to avoid it. Why? No state really likes taking away your civil rights. Nobody. Nobody likes to take them away. Even though Texas has some of the best laws around, because I go to nationwide stuff, our law rocks. So our law takes into consideration due process, timing, other things that other states, they don't look at that. So other states have public guardians. And then now you get into some real issues. So here we're still into personal responsibility for a little bit longer until, you know, every 2 years, you never know, because that's when the legislature meets, right? So guardianship, what's that doing? That's suspending your autonomy of somebody to make their own decisions. And I have to tell you, how many people want to have their decisions made by their 16-year-old child that's then going to be 30? Well, nobody, because in your mind, they're still 16 or they're still 12. When I go home to see my dad who suffers with Alzheimer's, my niece is still 12 in my head, and when they say, do you want your niece to pick you up from the airport? It's like, no, don't let her drive. I know she's 28, but I can't get 12 out of my head. So when you're talking about guardianships, it's very extreme. A lot of doctors don't understand it. A lot of attorneys don't understand it. It's difficult because we're all trying to speak a language that we've been trying to learn together since, I believe, the first Medico-Legal conference I went to was in 2005. And I believe Liliana Oakes was talking about guardianship. And it was so funny because she didn't have anything right. She was talking about law from another state. So a bunch of attorneys there, we were all like, whoa. So after that, I've been speaking since 2006, I think, at the GREC events. So, but God bless Liliana Oakes for getting up there. But we talked earlier about the informational letter. And one of the outlines, I think it was Barbie's, it said to get a hold of Martin Collins in Probate Court Number 2 if you were in Bexar County with an informational letter. That's not right. They have their own court investigator also. Her name is Sue Bean. And if you want her phone number, since Barbie started to publicize their stuff in her outline, I'll give it to you, because Sue has nothing to do. Just because we have 4,000 or 5,000 guardianships that come in every year, you know. So I say we work her. But that informational letter, that really is a great way to start. If you have warring families, attorneys, sometimes you may not want to be the one that just pushes right in and makes mom and dad upset because your client is the first to file. Sometimes your son or daughter needs to be the shining knight on the white horse and rescue mom from the big bad guardian ad litem. I prefer to be the bad guy. Let it be me, not your child. So we try to look at that as a resource and a strategy. And it's true that anybody can send this in. They really do like it in writing because that way there's some place to track. There's some new things that went on with guardian ad litem letters because, as you know, anything that's legal gets abused, right? And so now if you're a family member sending this in, they want you to swear under the penalties of perjury. Why? Because it was used to break up ongoing good stuff that was already happening. And the other sibling felt left out. So we have some little things now that when you send that in, if you're not the family member, you don't have it notarized, going through all that. But if you are a family member, then you're going to need to take that extra step and swear that you're doing this of pure heart, more or less. Now, we know that the guardian ad litem becomes an investigator, right? So the guardian ad litem really, they do not have the ability to make a medical decision. And I see this all the time. I'll talk to a young guardian ad litem, and they'll go, well, I signed the DNR. Really? Really? So remember, it's an investigative position, and what you're supposed to do as the guardian ad litem, as an officer of the court, is you try to protect that incapacitated person in a manner that will enable the court to determine what's in their best interest. Does not give you the power and authority to make medical decisions, financial decisions. Now, if you're a guardian ad litem, sure, you can take the nursing home bill over to their bank and ask the bank to cut a check out of their account, directly for that bill. You can do things like that. It doesn't cut you off from being a good humanitarian. But I get calls all the time from hospitals, social workers, and nurses. There's a guardian ad litem, and so why aren't they signing to get this person out of here? We need to have XYZ. We need to have consent for a non-life-threatening surgery. They don't have that power. So this is an investigator. That's the easiest way to think about it. Now, the investigator comes on, and usually we've been talking about this as early on, before a guardianship even is created. But a judge can appoint a guardian ad litem at the point of creation, at the point of modification, or at the point of termination of a guardianship. Because the judge is responsible for looking into the decisions of a guardian, The judge can appoint a guardian ad litem to go and investigate to see if that guardian is doing their job. And of course, because guardianship is the last resort, they can go over and peek into the powers of attorney. So if you have a power of attorney that's stealing your money because they're the power of attorney on your account, and a guardian ad litem can go over to the bank and say, I want to see how this money is being spent. They can use other law to stop that theft. So let's say we have, anybody heard of a TRO, temporary restraining order? Think about that as a document that you can use to stop, to start, or to continue, right? So the guardian ad litem, as an investigator, this is the person, we're going to go back and say that they're on at the very beginning, and they will look at everything, they will speak to the physicians, the care managers, whoever's there, and they're not going to make their own decision about incapacity. That's a little silly. They gather facts, but they should be very quickly heading towards medical. What does the geriatrician say? Do we need a neutral geriatric psychiatrist? Are you in a county with no geriatric physicians? As you know, you might very well be. So that person there has to look at everything and then make a decision with this information. Oh, well, are we going to start a medical power of attorney? Because you know you need a doctor's letter to spring that puppy into effect. Do you need your financial power of attorney sprung into effect? Anything that stops a guardianship from being filed, it's a hooray. So they can look at all that, and let's say, oh my goodness, they need to file, and they need to file quickly. There's an emergent situation. The guardian ad litem can take the medical certificate from the doctor, and they can file an emergency guardianship, a temporary guardianship. If you walk away with nothing today but this phrase, a temporary guardianship is for fire, flood, or blood. Y'all, all of y'all are pretty medical, so you know that comes up. It could come up very regularly. How fast does death happen? Everybody, blink your eye. Now, relate that to an old person living home alone, cooking on the stove with no sense of smell. So you see how it can come up very quickly. So the guardian ad litem, that's one resource, can file an emergency guardianship. There's no judicial declaration that that person is legally declared incapacitated. It's supposed to only last 60 days for everybody to cure the emergency, quiet things down, and do a little better job of figuring things out. And it's supposed to just be very narrow, just to meet the need. I mean, we filed one once because we had a lady who had been shot in the head. They had removed her skull for the brain swelling, right? Later, after things had, calmed down, they wanted to put the skull back on. But it turns out that was seen as an elective surgery. So you determine whether that one was an emergency or not. What I want you to know is that if you do the law correctly in here and you have malfeasance happening with the medical power or financial power of attorney, a temporary guardianship can suspend the authority of that person or not. So if you have somebody that walks into your VA and says, I'm the medical power of attorney, and I walk in and I go, but I am the temporary guardian, who rules? Look on the paper. You can't say that. It has to have specific language during the temporary to suspend the medical power of attorney's authority. You have to read the paper, right? So all of you only got a C on that question, but so we're going to try again. Okay, so now let's say there's no fire, flood, or blood, and that guardian ad litem's out there, and so they said, well, yep, Grandma needs a prosthetic brain, right? That's guardianship. If you were missing a leg, what would you go get? Go ask the VA transition people over here. You would get a prosthetic leg. Well, this is a prosthetic brain, guardianship, right? It's supposed to be to make decisions as they would if they had the brain that they used to have to make it, right? So the prosthetic leg is to walk like I used to. Not, it might be a new normal for me, but, the idea is to become the other person, to step in their shoes. When is that an issue? In San Antonio, when you have a large family and you have somebody that does not and is never going to be ready for daddy who's 101 to die, it becomes an issue. So is that daughter going to really be able to make a decision as her dad would? Let's hope so. But it goes back to training. When you're a family member, nobody really trains you in our county on how to be a guardian. That will happen one day, but it's not happened yet. So you have to depend on your attorney. So what I want you to do is, before any of you leave today, I want you to find out what attorneys are in this room, because it's important for you. And it's important for your clients, but it's important for you personally, because these are the people that are going an extra mile to learn. So I wanted you to be aware of that. Now, let's see. If you're going to file for a permanent guardianship, well, we heard a lot of talk today about a full plenary guardianship. That's an all-encompassing, that surrogate brain is going to make decisions for all areas of that person's life. But it can also be limited. The IDD community fought a long, long time ago, way back in '97, to bring law into existence for this community to be able to spare some of their rights, change and modify those rights over their lifetime, and that is called a limited guardianship. Now look at the same attorneys that are in the room, because they're the only people that you're going to find that will take the time to craft that document. Your other attorneys think that it's a form out of the computer, that everything is a full guardianship. That's not so. So if you have an IDD person who has the capacity to vote, has been working on it, it can happen. Now, it's also kind of a scary thing when you have someone who is born IDD, they have an IQ of 50, and their parent wants them to drive. One of the things missing in the earlier slides today was it's not just driving, because a lot of elderly people know how to press the pedals and steer. It's safe driving. And if you ask any of your neuropsychology people, they're going to tell you there's no one test for that. It depends on whether they've ever driven, how long they were driven, what their brain issues are. So it's a very complicated moment. The physicians that do these kind of evaluations for us in Bexar County, they often extrapolate. But oftentimes it's the attorney or the guardian ad litem that takes a picture of their car with the 20 little new dents on it and the picture of the garage doorway where they've hit it and run into it, and that's fairly new. That's telling information. So now, what else can we do? We can look at that big permanent guardianship as the only method to bump off the powers of attorney. Because the attorney is going to have to go into court and say, look, guardianship is in their best interest. The power of attorney is not working because of XYZ. Either they got that power of attorney at a moment where they were incapacitated, or they were highly unduly influenced, right? And that the guardianship is the best way to go. Generally, what attorneys do is they come in and show that the power of attorney is probably stealing. How do we do that? Well, we get a copy of the check from the bank. We get a copy of the check showing that the power of attorney used the little old person's money to bond out their own son out of jail. So they're not very smart when they go to steal, but they are very, very dedicated about it. And I always say that APS and the criminal people would never get involved if the bad guys and gals, because it's an equal opportunity theft, if they would do a good job in caring for the person. But generally, they don't. They get a little bit too greedy with the money and a little bit too lax with the care. So then it does get called in. So, and I feel really bad for Sonia and her people. They picked on them all day. But APS, God bless them. They really do God's work out there. And let me tell you, for 22 years, I've watched Sonia Samples work cases. She's one way knowledgeable person. And if she can find a way to avoid a guardianship, well, by golly, she will find it. So now let's go on, Mark. Let's hit it. We're going to go on to the more fun things, the American icons. If you think, let's see, you got it? La, 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 la. Here we go. Rosa. If you think what happened to Rosa Parks, Mickey Rooney, and Casey Kasem recently cannot happen to any of you in this room because you are not rich or famous, think again. These same courtroom dramas happen right here in Bexar County in our little humble statutory probate courts. So here is the Reader's Digest version. Now, these were very complicated cases. And what you're going to see while I talk is just beautiful pictures of these people throughout their lives. So here's the shtick for Rosa. She was born in 1913 as Rosa Louise McCauley. She married in 1932 to Mr. Parks. That lovely gentleman died in 1977, and they never had any kids. 10 years after she became a widower at age 74, her and her old best friend formed a nonprofit, of course, around civil rights, teaching the civil rights movement. That sounds very reasonable for this honorable lady who took her life in her hands for all of us so many years ago. A few years after that, that woman was awarded the Presidential Medal of Freedom. She was 82. At 85, in 1999, she was awarded the Congressional Medal of Honor at 85. And that's when she signed her will, her trust, and her powers of attorney at 85. That's her first estate plan. That's what we call them, estate plans. A couple of years later, she amends the estate plan and brings in another old guy to be a co-everything with her old BFF, I call him. And what did that trust do? Well, it gave 90% of her estate to that nonprofit based upon her life, and 10% to her nieces and nephews. Are you feeling the litigation coming up? So at 89, as the story goes, she had trouble paying her rent, and the church had to intervene to help her, and that's the year that the medical records first used the word dementia, 89. That's also the year that her old BFF became her caregiver. That was her new life plan. Now, she dies at 92 in 2005. How fast do you think it took them to start the litigation? I think it was right after the funeral. They went to the lawyer's office, and the relatives said, oh, no, undue influence by her old BFF to give most of her everything to her nonprofit. Or, in the alternative, she was so incapacitated with dementia, she shouldn't have been able to sign a document. Those are the two things that we see all the time when you die and people are not happy about what they got, right? How many of you think leaving something to your children or leaving something to you entitles you because you've put up with your parents your whole life? How many feel entitled? I do. My mother beat me till I was 30. So absolutely I feel entitled. No, I'm kidding. So they immediately begin that litigation. And they said, oh, she had dementia, so she shouldn't have been able to sign anything. At the time of her death, she only had an estate worth $372,000 plus her memorabilia. How much do you think that was worth? 8 to 10 million, because the judge had it evaluated in 2006, and then it went under lock and key. So let's see what's happened since 2006. Well, anybody check? I think it's still 2014, last time I was checking the date. All of her memorabilia is still under lock and key, even though the original nephews and nieces, they formed an agreement with the old BFF. They're in agreement. They know what they're going to do, but it's still in litigation. Everything's still locked up. Who do you think is going to get most of the money? There you go. There's my medical people. I knew it. Y'all are a lot more outspoken than you used to. You just go outside and hear, those lawyers. Okay. So, you know, Rosa, it's really a shame when you look at her photographs and you see just what an honorable person she is to America. And we will never see any of her stuff until all of the peripheral litigation has a little bow on it, and all of the, what my dad used to call bean counters and bloodsuckers, got their share, right? And my dad, when I was going to law school, he'd say, you know, the 20% rule, always remember it. I said, what's that? He goes, a lawyer never stops until they have 20% of your net worth. Ask the lawyers in the room. Okay. So this is Miss Rosa Parks, and I'm going to move on to Mickey because he's really one of my favorite people. He was born Joseph Ewell Jr. Anybody know that? Isn't that cool? So now, oh, well, Mark Johnson does because he knows all that history stuff. Here's my favorite thing. Unlike my grandmother, he was actually married 8 times. His last wife's name is Jan, and he married her in 1978. Now, by 1978, he already had 8 biological children, and he took on 2 stepchildren. So he and Jan lived in their little Mickey Rooney mansion until age 83. Or actually, they were still living there in age 83, but that's how old he was when he first signed his will, trusts, powers of attorney. And his earlier documents named his current wife as a beneficiary, so every husband in the room, that is the right thing to do, according to my grandmother, and named her son, the stepson, Chris Abner, as the executor. So then what happens? We get 4 years into his elderliness, and at 87, he couldn't manage the stairs in the mansion. So I want you to think, Mickey couldn't manage the stairs in the mansion, and then after happy hour, say that 3 times. Okay, so what he did, his life plan was that he and his wife moved in with that same stepson that he gave the power to be the executor and the power of attorney to. So that's at 87. At age 90, here comes Mickey in front of the Special Senate Committee on Aging, and he talked about being abused, neglected, and exploited for 3 years by his son-in-law, his stepson. So what happened was he said that there was a slow course of conduct which escalated into verbal abuse, bullying, intimidation. He was refused food and water and medication unless he did what his stepson wanted. He felt scared, depressed, and disappointed in himself for putting himself in that position. Now, hopefully you'll see the picture of his stepson coming up. He's a great big guy. So can you imagine feeling that scared and depressed as your American icon with your McMansion over there? He moves into a little tiny house with the stepson. Now, somewhere in here, the legal system intervenes. A long-time old attorney that probably did those old estate documents surfaced, got himself appointed, and went over, started visiting Mr. Rooney, and found that this was not a good situation. Mr. Rooney finally made an outcry to the attorney, and the attorney went into court, filed a temporary guardianship, became the temporary guardian, got him out of that guy's house, and by then the theft or the exploitation was $2.8 million. Now at 91, a few months after this is him testifying in the Senate, at 91, that guardian did pull him out of that stepson's house, and then he put him in the other stepson's house. Okay, I'm pretty sure this guy had never been trained as a guardian either. About that same time, the attorney gets the wife to sign some papers to waive her inheritance and different things. And, you know, she doesn't know really what she's doing, she says now. But we march ahead a couple of years. He's 93, And the guardian, who's the attorney, who's the everything, gets Mr. Rooney to sign a new will and trust document. So March 11th, he signs new papers, and who do you think he's going to give his estate to? No, the new stepson that's so good. No, attorneys, we don't want to inherit anything. We want to earn our legal fees. So the caretaker stepson inherits the attorney. They like to make us, power position. So that attorney becomes the what? Executor. And this document also disinherits his wife, who he's still married to, and 8 biological children. Do we hear litigation coming up? Yes, we do. Now, because they had to sell the McMansion to pay for everything along this way, what he really had at the time of his death was $18,000, and then about $38 million in licensing rights and memorabilia, right? So it's not always the cash for these people, but look at it. I've seen people fight over $600. So $18,000, that's pretty lip smacking good. So that's poor Mickey towards the end. He dies a month after making the new will, of course. How long did it take them to go to court? 5 days. The guardian, who's now the executor, files a TRO to prevent poor little Mickey to be buried next to where he and his wife had bought some family plots. How many did they buy? Well, enough for her and him and her stepchildren. So the lawyer says, oh no, he didn't want to be buried next to that bad guy. So they do this whole restraining order. They finally settled, because Mickey did get buried. But what happened right after that? Well, the bio children and the wife sued to invalidate the will and the trust based upon what? Incapacity to sign the documents, or undue influence by who? The attorney and the good stepson. And by the way, my favorite part of this whole story, somewhere in here, what I call the good stepson, the last stepson to care for him, now uses Rooney as his last name. Looks good to the court, doesn't it? So now, this is our dear friend Mickey, and we're going to move on to my other one, because I am a child that grew up watching TV and dancing around. And Casey Kasem, boy, I was really disheartened to see old Casey Kasem have anything to do in the news. He was born in 1932 as Kamal Amin Kasem, and he married in 1980 to a lady named Jean. He only had 4 biological children from a prior marriage. Oh, there he is. That's the one that was the first stepson. Yeah, intimidated, scared, bullied, intimidated. Yeah, you can see it. So, and that's him after the funeral because they loved him. Yeah. So it was the best time pulling photographs for this. I really loved it. I was like, wow, she's really tall. So Casey Kasem, he had 4 kids from a prior marriage. Not bad. That's kind of average. San Antonio, I think we have more. But 4 from a prior marriage. Oh, this case was never about money. He was worth $80 million, right? Never about money. So at age 75, poor Mr. Kasem is diagnosed with Parkinson's. That same year, he signs a medical power of attorney to his daughter, who's married to a doctor, right? So my son-in-law, the doctor, is going to help make my decisions for me. Sounds reasonable, right? Well, 4 years later, time goes on, the disease progresses, he's 79, and lo and behold, he signs another medical power of attorney, this one giving his wife the decision-making ability for him as he goes through his disease process. Between 79 and 82, things go wrong. There's the wife. I love her. I'm a tall, thin blonde. So somewhere in these little 4 years, the current wife starts restricting the children's visitation. The children counteract this And the only way, I'm sure they dealt with an attorney, not, they do a protest in front of the house. You'll see these pictures. I gotta love it, gotta love it. So the wife is like, no, you're too disruptive to your dad. I don't want you visiting him, or he's asleep, or, we've all heard these stories, right? There's a pushing you away, isolating your loved one away from you. So the children hold this protest in front of the home of Mr. and Mrs. Kasem. How do you think that this wife felt? Oh, those children, they just love their dad, right? So that's his certificate of death. By age 82, that's 3 years after the protests and the restricted visitation, he declines. He's really down to the point where he can barely talk. And his daughter does go over to see him. They get in a fight, she and the wife. And yes, hamburger meat is thrown. I went right home. I was like, where is my hamburger meat? So, hamburger meat is thrown. Guess by who? Stepmother whirls it at the daughter, right? You know what that daughter did, didn't you? That daughter went immediately to an attorney. She hit me with meat. I'm over it. So it does it for her. So she goes and gets a temporary guardianship in California. She wants to be the guardian of his person. Does she care about the money? We hear this all the time in our offices. I don't care about no stinking money, right? Well, that's oftentimes very true, because now this is territorial. So she goes in and she says, Judge, that tall blonde wife ain't taking care of my daddy. And the judge goes, oh my God, he's an American icon. I'm going to let you be the temporary guardian, and we're going to get our court people, the ad litems, everybody to visit. He gets a doctor to come in and evaluate Mr. Kasem, and lo and behold, what happens? The mom moves dad. Mom moves dad over to Washington for vacation. Gotta love her. So daughter goes, well, what happened to dad? This is the protest in front of the house. How would you like that in front of your house? So, all right, so Mr. Kasem goes on up to Washington. Daughter follows suit and gets her attorneys there. The attorneys say, oh, she needs to be the temporary guardian in California and this and that. And the judge in Washington says, you know what? Let's give Mr. Kasem food and water. We're going to appoint a doctor to evaluate. And he tells the wife, give me everybody's passports. So he turn over Casey Kasem's passports. Now, the new doctor comes in and says, it's Lewy body dementia. Well, you know that excited the daughter. You know it did. Because, oh, Mom was wrong in what the original diagnosis is. Well, at this point, really, do we care? No. But guess what happens? Well, the doctor is ordered, or the temporary guardian is ordered, to follow the recommendations of a court-appointed doctor for the treatment and care of the end-of-the-life decisions of Mr. Kasem. So who is really making decisions? The daughter who loves him? The wife who loves him? The documents that he signed off and on? No, a stranger. Hope it was a geriatrician. That's all I got to say. So in 3 months, between March and June, the daughter had filed in 2 different states. A judge is saying that the medical treatment's going to be what that doctor over there says it should be. And, you know, this just never goes well when you have somebody that doesn't know your family making your decisions. So they're in there trying to figure things out, and they're in court, and they're screaming and yelling. What happens? Mr. Kasem is sent to the hospital. He has an infected bed sore. That's what the news reports say. You think with $80 million they weren't turning him every 2 hours? Sure they were. That could have been Kennedy ulcers. It could have been anything. So it could have just been a natural thing going on with his body. But what happens when you put an attorney beside a natural event that they don't know about? Well, it's more litigation. So, poor guy, he goes off to the hospital, and he did die. He died, and you're going to love this, on Father's Day. Now, I think that's very, very important. That whole family should have been on their knees, destroying this man's peaceful days. But let's look at the last statements by the children. This is the last reported statements that I could find. Dad would have wanted to be with his friends and family and to die comfortably. What do you think Mom, his wife, stepmom, what do you think her last statements were? The children wanted to prematurely end his life. He was such a fighter. Right? Those are real feelings. Those are real feelings. And so it's very, very sad. Now, what happened to Mr. Kasem after he died on Father's Day? Well, his wife went to the funeral home and removed his body. As of September 2014, his body is still missing. So much for being territorial over Dad. So very, very, see, he's missing. He's still missing. Right? Don't need a passport to have a body shipped anywhere, turns out. So now, why am I exciting all of your prurient interests in the afternoon? Well, I really wanted to give you some life lessons. As health and cognition decrease, old rifts widen and increase. Count on it. A life plan, because as we saw, not too many of these people had a good life plan. They had estate planning documents. But a life plan is just as an important thing as an estate plan. Here's your other lesson. Waiting to plan may invalidate the plan. So when you're doing this as an ancient person, someone's going to question that document. When you get a plan, I don't care whether you're 40 or 80, chat it up. And if you're going to front out a son or daughter, chat it up louder. Say, I want my current 20-year-old wife to make my decisions for me. Say it out loud. Tell your doctor, right? So here's the lessons for all. We have medical and legal professionals in here, and we count social workers as kind of the referees between the two. Now, I like social workers. I didn't know that when I got out of law school that there was a manual that said that we were natural-born enemies of social workers. I found that out through social workers telling me that. But they're very, very important. But here's what we need to do. We need to encourage the conversation about a life plan. Here's the facts. Elderly people, senior citizens, they're totally into having an estate plan to transfer their life at death. But very, very few will research or make any kind of an investment in disability planning for the most common diseases of old age. Your hip, right? I gotta tell you, after age 55, my hip is not the same. So here's little Mickey Rooney at age 87 looking at the McMansion stairs going, oh, I don't think I can do those anymore. I'm 87. Really? So no investment, no talk. The physicians in the room, please talk to your patients. Look, you have XYZ. This is how the disease progresses. And this is what you might need to look at as a life plan. Macular degeneration, you might go blind. The detached retinas, you might go blind. Whatever. So look at it in a life planning, not just estate planning, who's going to get it when I die. And I have to tell you, I like Texas. They have an honorarium now for pets. I'm leaving everything to my cat, my then existing cat. And I think Kathy Elder is going to be my trustee for that. So anyway, so we have a lack of seniors understanding this. So we really all have to have that conversation with them. You need to talk to them, lawyers, and tell them to talk to their powers of attorney about what kind of decisions they want to have made. Talk to the power of attorney about being the power of attorney. I have waited and seen over the years these lovely friendships, and they gave the power of attorney to this person a long time ago. The minute there's need, boom, that person resigns. If you're going to resign, tell them no in the beginning. You know, I may not want to be your power of attorney. I may not want to be your trustee. So talk to them. And then if you are the future surrogate, the future prosthetic brain, find out what they want. Because here's the fragileness of the documents. For a power of attorney, they can only do what the principal who gave them that power will let them do. So here's my big example. My brother is a Vietnam veteran. He raised his children and he beat it into all his siblings. He is strictly Buy American. I mean, you will really go to his house. There is nothing foreign made. So if my brother ever gets a guardian one day, do you think they can buy, I don't know, a foreign car like a BMW or something to drive him around to appointments in? No. Can they put him in a t-shirt made in China? No. My brother will spontaneously combust. You know, so you can only do what that principle is going to allow you to do. So if you're in the hospital and you're the medical power of attorney and they need to amputate the baby toe and the person's telling the surgeon, heck no, you're going to sell my toe to China. I know it. You cannot override that no with a power of attorney. You have to go and get the guardianship, because the documents are meant to be fragile. That's why conversations really help. So if you're going to encourage the conversations. Now, when I came in today, and I think we still have some people in here from care management, let me tell you why this is important. They're the portal for information for dysfunctional families. God love them. I hire them every time. I don't want to be the portal. Let them be the portal. Let them create a website all about daddy so everybody can read on it, right? So use care managers. Yeah, it's expensive. Is it worth it? Well, Casey Kaseph's body's still missing. Yeah, it's worth it. So let me give you the very last story, and I'm almost at the end. There's a story that near the end of his life, Ronald Reagan used to go with his provider to a park every day and walk, and then he'd sit on this bench and he'd watch these little kids play. And every day one of the little girls would wave at him and he would wave back. And one day the little girl came running up to him and introduced herself to him and proudly announced her name and that she would be in kindergarten the next year, and asked him who he was. And he said, well, my name is Ronnie. I'm an actor. Now, imagine how strong a disease it must be to rob that from a person like Ronald Reagan. Now, imagine that disease in your brain. Look at your family dynamics. What are your end-of-life decisions? Do you really want them made inside of a courtroom amongst all the litigants claiming their love and devotion for you as more than the other side? Look, take heed. You don't need to be a big, rich, and famous person. You already are a person. This can happen to you. So go home, talk to your next of kin, tell them whether or not you want to be freeze-dried like I do, right? And if you have any questions, I'm going to be here during the break. My name is Kelly Cross, and thanks for staying awake this afternoon. Thank you.
Al calor de una copa de vino, sentí valiente